When you're in the middle of divorce and there are custody issues of time sharing and you've got a past of really fighting over the kids, and now you're living in separate homes and you're having your own time with the kids and you're just triggering each other over and over, there's a real tendency in these cases to send nasty text messages, to speak negatively about the other parent in front of the children, even if it's inadvertently, even if it's on the phone with your mother and you're just dissing her on the phone with your mom, or you're dissing him on the phone with your mom. The kids are in earshot, they hear it. Guess what? When it comes time to make representations to the court about what kind of a time-sharing arrangement is in the best interest of the children, one of the things that we're going to look at, the court is going to look at, is evidence that one of you or both of you is not encouraging the children to have a healthy, loving relationship with the other parent. Part of that is talking smack about the other person in front of the kids. It's having text messages where you are just triggering each other and having them lying around where the kids can see it. These are all things that will become evidence, especially those text messages, so please refrain. And now's not the time to insult each other. You already did that. Now's the time to be there for your kids. Remember that it doesn't help them to think that their mom or their dad is not all that in a bag of chips. If you're in the middle of a nasty divorce, a high conflict divorce, and you've got kids, and there have been some incidents of violence in your household, either, again, as to you by your spouse in front of the children or not, that are documented. There's been a DVI, a domestic violence injunction, entered by the court. There's been an incident of child abuse. There's been neglect. There has been misuse of children's funds, taking their money and doing that was allocated for something that the kids needed and doing something else with it. Things that are truly not in the best interest of the children. Those are the kinds of things that you definitely want to keep a log of them, a sort of a chronology, a timeline, if you will, prior. And if you can but before you start the divorce process and start hashing through these time sharing and parenting issues with the court, if you can have that right out of the gate to provide to a lawyer, they can help you wade through what of this matters and what doesn't. So initially, the best case for you, my suggestion out of the gate is that you do document things that you think are problematic. They may not be. They may not have any weight in a court of law. However, if you think they're significant, go ahead and write them down. What I do suggest is that you not attack your spouse with your timeline and your chronology and your log of all the grievances. Instead, take that to a lawyer, let them walk through it with you and say, here's what matters with respect to time sharing, and here's what doesn't. It might be that none of it matters, in which case you can stop keeping that timeline. But if some of it does matter, then we're going to keep our eye out for the things that do. And at this point, you don't know that. And so the best thing to do is to confer with somebody who knows, and that would be a lawyer. Okay, so you've got this amazing time-sharing plan with your spouse, and your schedule changes, and you had to miss time-sharing on your day, and then you had to miss again, and you had to miss again, and you had to miss again. At some point, those misses are going to become aggregated, and your spouse may have the right to ask for a substantial change in circumstances, being that you are not showing up on your time sharing days and you're not having the kids when you're supposed to, you're not spending time with them, And what that means is not only will there be a modification of your final judgment that includes your original parenting plan, it also means that things like child support will probably change if that time-sharing plan changes because of the number of overnights that you have foregone as a result of not showing up. However, I will say this, if you have missed time-sharing with the kids when it's scheduled for a valid reason, and you have asked your spouse, your former spouse, for makeup time sharing, that's a reasonable request. And that's also something that you might want to put into a parenting plan. Say, hey, how do we ask for makeup time if we need flexibility around time sharing? And what's our routine going to be around that? So there's an opportunity to get that time back so long as you and your former spouse are flexible with one another and respectful. Another mistake that co-parents make is the way they choose to communicate with one another. Okay, so previously you were living in the same home and you met face to face. And so now you think when you drop off the kids that you're just going to talk about stuff face to face at the door. And you know what? That does not end well. It's just not going to. So refrain from that unless it's minor stuff. If it's a major conversation that you need to have, then that needs to be scheduled. It needs to be some other way. But typically, communicating face to face at the front door during drop off is not a great idea. Texting. A lot of people love texting. We live in a text-driven world. That's just what we do now. However, think about this. When you text your partner or your former partner about the kids in the middle of the day, remember how it feels when she or he does the same to you. When they text you out of the blue during your workday, does it emotionally trigger you? It might. I don't know. If you're past all that, text away. Great. If, however, you guys are still at odds and there's a lot of emotion left, then texting from your cell phone is probably not the greatest idea. Instead, what most of us divorce lawyers love is an application called Our Family Wizard. So this is my ad for Our Family Wizard. The reason I love it, and most lawyers love it, is that one, it's one central location that both of you are going to communicate about all things child related. You can put the kids' schedules in there. There's a calendar. You can exchange information and receipts about kids' expenses that you're sharing, all the stuff. Child support payments can get tracked in there. All of it goes there. Any messaging can go right there about, unless it's an emergency, then for sure use your cell phone text. But the reason that I have seen Our Family Wizard or similar, co-parenting apps work so successfully in the context of co-parenting is that it allows each of you to decide when you are going to address the necessary communication between the co-parents. You don't have to see that text in the middle of your workday or a dinner with a new love interest or the kids at the beach. You don't have to take that call right now. You don't have to get on the phone with him or her. You don't have to, get triggered by that. Instead, you control when you're going to address those communications. And that's a good thing. If you're having a tough time with co-parenting issues during or after your divorce, give Brava Law a call and we'll see what we can do to help you through it.